I'd like to give each of you a minute to get some final thoughts, some key takeaways you'd like to leave with the audience. We're going to do a minute each, if we could hold it to that. We're going to start. We're going to do it in the order of sequencing that we have the presentations in. So we're going to start with John Jarrahs. John, some key takeaways, please.
In reasonable royalty cases, I would highly advise examining closely industry licensing practices and party practices to determine how patented inventions are shared and to determine what kind of royalty bases are used. I would also examine the claims of the patents at issue to understand how broad or narrow they are. I would absolutely apportion somewhere, whether in the royalty base or royalty rate, and explain very clearly and directly how the apportionment is being done and on what basis to attribute value to just the patented invention.
Thank you, John Jarrahs. Dan McGavrick, would you please give us some key takeaways from your segment?
I'd say in a lost profits context, it's always important to look at issues related to apportionment because, particularly in today's markets, rarely, if ever, does a single patent cover an entire product. So it's always important to isolate the incremental value of the patented feature. In a lost profits context, we're really looking at the incremental lost profits due to the patented feature versus alternatives in the marketplace. So I would say that regarding the Supreme Court decision, I will reserve judgment on that, but it could radically change the way we actually calculate lost profits if that decision is reversed. Thanks.
Thank you, Dan McGavrick. And finally, Dr. John Scalf, some key takeaways, please.
Sure. So there's going to be many ways to apportion damages. You just saw a limited sampling of them in what I presented. But each of those ways is never going to be perfect. It's either going to be extremely hard to implement or it's not going to perfectly measure apportionment. So the key thing is to basically ground each method in the facts of the case and come up with as many reasonable methods as possible. You need to have alternative apportionment methods set up both for the credibility of one another, of each method corroborating one another, and also to mitigate any risk of any one of those methods not being accepted by the court.